It's time for Michigan's retirement coach, Mike Douglas.
Estate planning is complex. So we are going to run through the ABCs of estate planning and give you a bird's view idea. Because I said to Mike, before we start this recording, we only have 15 minutes to get through this, but we're going to try to break it down. Just some basic fundamental knowledge about the ABCs of estate planning and things you need to be thinking about. As we're going through this, if you have specific questions on the things that we talk about, if you want to reach out to Mike, by the way, certified financial planner, Mike Douglas, a.k.a. Michigan's retirement coach. MichigansRetirementCoach.com is our website and where you can go to connect with Mike and his team. We also have links posted in the show notes. I feel like we've geared up for the 5K. We're getting ready to jog here, Mike.
Here we go.
All right. ABCs of estate planning. Let's start with the letter A. A stands for assets and avoiding probate. So, step one, what counts as an asset?
Just anything you own, right? It can be your retirement accounts, bank accounts, a home, a cottage. It can be a business. It can be digital assets like your online accounts. So anything that you own that is part of your estate, and your estate is just the overarching Douglas family, right? So anything that we own is an asset. It can be a car. It can be all types of stuff.
Got it. All right. So thinking about our assets, because it's, I guess, assets that get us to probate, right? That's what if you've not properly planned, the separating of those assets is what can bring somebody to probate. Why do we want to avoid probate?
So probate is just a court process of cataloging and taxing and disseminating your stuff.
Yeah.
Think of it that way. So there's three things I don't like about probate. There's a lot I don't like, but here's the big three highlights. Number one, it costs you 3 to 5% typically. So if you put $1 million through probate court, it can cost you $30,000 to $50,000 in fees.
Got it.
I don't like that.
Yeah.
Number two, it typically takes upwards of a year, if not longer, to get through probate court. So I die, my stuff goes through probate, my kids don't get it because I didn't do it properly, up to a year from now. And dealing with courts and all that stuff, it's a terrible thing.
It's stressful, yeah.
Then also, the last one is the cataloging and making record of all of our stuff.
FYI, public information if you've got something private.
Public record.
$10 million that nobody knows you had.
Yeah, public record. So you think creditors and debtors and people who now know your kids just inherited this money, and then your kid gets in a car accident and they go, well, it's public record that kid just got $2 million.
Yeah.
Okay.
Got it.
So I hate all three things of that.
Yeah.
We want to avoid probate whenever possible.
All right. I guess avoiding probate then, how do we avoid it? Or in combination, what's the most common mistake you've seen somebody make that has caused a family to end up in probate? What can we know to do better about?
Yeah, I think the biggest problem that people do, the mistake is assumption, right? Oh, I have a will, so my stuff doesn't go through probate.
Okay.
Well, that's not true.
Oh, okay.
My accounts aren't titled properly, or I haven't done my beneficiaries, or I didn't fund. People get a trust, but then never name the trust as a beneficiary of their accounts. So I've got this safety deposit box that never gets the money put into it because I didn't ever send the money to it.
That's a problem that I've actually recently heard about that I was baffled by. You can set up a trust, but if it's not properly journaled, is what the funded.
Yeah.
So how does that even happen? I guess if you go to a lawyer and they help you set up the trust, but they did not clearly say to you, okay, now you got to go to your financial advisor and have this set up so that the assets are in the trust.
So there is, if you think of it like this, there is a trust is a safety deposit box.
Okay.
Right?
Yeah.
When you put stuff in the safety deposit box, it's protected.
Yeah.
If you never put it in there, it's not protected.
Got it.
So the way you put it in there is you either say that on my 401k, if something happens to me, it goes to my wife. If something happens to both of us, it goes to my trust. So now I've a written set of instructions that says if something happens to us, take the money, put it in the safety deposit box. And then you go through and you say, what happens to my house? I can put while I'm living, I can put my house inside that safety deposit box right now. That way it's protected. So you have to fund a trust.
Okay.
The lawyer's job isn't to fund the trust. The lawyer's job is to open a safety deposit box for you.
Yeah.
Then you need to go around and they'll give you a list. Here's what you need to do. Here's how you do it. But you have to go back and get your Schwab account and put it in there as a beneficiary. Or you go in and you open a trust account that is already inside the safety deposit box.
Yeah.
And then you put money into that Schwab account. So there's ways to, but you have to fund it.
Not simple. Sounds complicated. Okay. But this is where you're here to help. Real quickly, because like I said, we got to keep moving. But can you explain in like less than 30 seconds the difference between a will and a trust?
Yep. So a will is a set of instructions.
Okay.
Here's what I want to happen. And here's where I want things to go. Here's what I want to get what. Because again, for a will, you typically would catalog your stuff. All right, here's my car. I want the car to go to Mike. I want the tools in the barn to go to Chris and whatever, right? You go through all that list. A trust is a protectionary safety deposit box that says creditors can't come get the money and probate can't get the stuff. You use a safety deposit box for stuff that you can't put a beneficiary on.
Okay, got it.
Right?
Yep.
So again, like my car, I can't put a beneficiary on my car. So I put in the will that it goes to, my son or whatever else. And so there's just ways. You use a trust as a safety deposit box for things you can't put a beneficiary on.
Okay, got it. All right. Speaking of beneficiaries, let's move on to B. B is for beneficiaries and basic documents. So how often should we review our beneficiary designations? Because perhaps more importantly to point out what could happen if somebody forgets to update a beneficiary, like after a divorce, for example.
Yeah. So you'd want them updated every 1 to 2 years. And most of the time it's, can you just show me how it's titled?
Yeah.
Life doesn't change that often to need to redo it all the time.
Okay.
It's good to check back in on it. But think of this. Anytime something important in life happens, you should probably check.
Okay.
My kids turn 18. Oh, now they're an adult. Now things should maybe change. My kids got married. I got married. I got divorced. Someone in my family died. Well, they may have been a beneficiary. One of the worst things we see all the time is, there's a divorce that happens and we never take the X off of the 401k. And that's not good because they didn't get that 401k in the settlement. When you go through divorce, we divvy it up and the attorneys, work hard to earn their money and to do their thing. And then what happens is once that's all settled, let's say that you keep your whole 401k, but you never took your ex off as a beneficiary. And then you get remarried, build this new life and all these things. And then you die and the money goes to your ex because it doesn't matter what your will says. It doesn't matter what your trust says. The beneficiaries on your accounts trumps all of it.
You taught me that recently. And that's, I think, such an important takeaway. Check your beneficiaries.
Right. And think about when you have minor children. Right. If your kids are young, typically you don't name them beneficiaries, you name someone else,
right.
Your sibling or whoever would get the kids. Right. So while my kids are young, whoever gets my kids would also get my accounts. Right. If something happens to Kimberly and I, well, then my kids become adults and they should get the money. And if I don't ever go back and change it, well, then all of a sudden it's like, oh, crap.
Got it.
My brother-in-law gets my money, even though my kids are supposed to get it.
Got it. All right. Update your beneficiaries. What are basic documents? Also for B, what are basic documents that everyone, or at least for the most part, all of us should have?
Yep. So there's 4 big ones. Okay. The first one is a will. Mm-hmm. The second one is a durable power of attorney for finances. Mm-hmm. The third is a healthcare directive or a living will.
Okay.
And fourth is a HIPAA authorization so the loved ones can access medical info.
Okay.
So the will is the instructions of what happens to all my stuff.
Okay.
The durable power of attorney for finances. Think of it this way. You don't die. You go into a coma. You get in a car accident and you're in a coma. Who makes sure that the electricity bill gets paid? Who makes sure that your mortgage is paid? Who makes sure that your finances are able to kind of keep moving until something happens with you? Well, I need someone who's got the authority to do that in my name. That way they can make sure that everything's good. The healthcare directive or living will. Do I want to be resuscitated? What things do I do? Do I want to go on a ventilator or not want to go on a ventilator? What do I want for my body? Because it takes some of the pressure off your loved ones in tough moments too. Mm-hmm. And last one's a HIPAA authorization. So loved ones can access medical info. Sometimes we ask our kids or someone to make a difficult decision and they don't have all the information.
Yeah.
So who's allowed to, right? Make sure your spouse or your kids or whoever's going to make those decisions has access to the info they need to make a good decision. So a will, power of attorney for finances, healthcare directive or living will, and then finally a HIPAA authorization so your loved ones can see your medical info.
Review your forms. Make sure your beneficiaries are updated. Make sure you've got your basic documents, updated. Because these documents can also need updating, right? As you move through life. Once you have them, they're not necessarily stagnant.
Yeah. Again, minor children, divorce, If a child predeceases you, if, like what happens, well, my wife gets my ability to make those decisions for me. But what if she predeceases me? There's a lot. So just keep it current. Again, if you're trying to do it by yourself through Google Forms and LegalZoom, you're leaving a lot up to chance versus if you work with someone who does this all the time.
Yeah.
Because they would know, we got to update this. When you come in, we're going to knock all 4 of these out and we'll be good to go.
Got it.
Versus doing it on your own, you're kind of quarterbacking it.
All right. C is for coordination and common mistakes, because estate planning is not just legal, it's also financial and personal. So you might need your attorney and a financial advisor, sometimes a CPA, and some circumstances needing all 3 of them working together. So how do you help coordinate? How do you help your clients in this coordination space when it's you and a CPA and an attorney?
Right. Well, there's kind of 2 different models, right? So the one is for a lot of our clients, we do their estate plan and we do their taxes. And their finances. So for them, it's a relief because it's all in one spot. But there are definitely those that we work with. They say, well, I've actually got a really good CPA I love, and I've already got my estate plan done. Can you just work with us? Absolutely. Get us their info. And I set up a call where we kind of go through, hey, just, we're all on the same page here. We're working for Heather's family. Let's make sure that we just understand each other.
Got it.
And we kind of go forward from there. Okay. And you see the mistakes being made of one, let's say you get a will and trust done, right? 20 years ago, and you get it done when you're 45 years old. Now you're 65. When you were 45, that estate planning attorney was 60. And now they're retired, dead, or gone. Their office isn't even open anymore. Mm-hmm. And you have a will and trust that you say, oh, now it's time. I need to do some stuff. And you go, and they're not even in business anymore. Mm-hmm. Who do I talk to? Mm-hmm. So we need to keep an active, engaging conversation going on about this because life changes and so do your documents. So I think the mistake we see there is that people do not keep updating things as they go. Okay. They don't fund the trust after they create it. Again, they leave things stale. They don't update their documents. They ignore digital assets more and more and more.
That's big. That's getting much bigger.
Oh, man. Like an old 401k or something that all I had was an online login to Empower or whatever. You need to know the digital assets. What are the passwords? My dad, he's very tech savvy. And he just says, oh, if you need anything, there's a jump drive. And he's told me where it is. And I just grab the jump drive and we get them up and running, assuming that we still have jump drives by the time I need it. Right. And then the last one's kind of figuring out that there are taxes to settle an estate. So if you live 1 month into 2026 and die, your estate has to do a tax return next year for the income you earn this year and settle up. Some of the investments will be taxed before it goes to the beneficiaries. If you have a non-qualified annuity, it'll be taxed before it goes to beneficiaries. If you have certain things, it'll be taxed before it goes to beneficiaries. Other things can be completely avoid tax, and we can clean up your tax bill in advance with good planning. But not thinking about taxes on your accounts is another mistake. People say, oh, well, it'll work itself out. It'll almost always work out in the government's favor if you treat it that way.
It will work out for somebody. Might not be for you or your family.
Yeah, the government will work it out real quick.
Or not. They'll drag it
real
out.
slow if it goes through probate.
Oh, yeah. Okay. A is for assets and avoiding probate. B is for beneficiaries and basic documents. C is for coordination and common mistakes. Before we close, did I miss anything? Anything else to hit on?
Yeah, I think sometimes we think that things aren't a big deal, but to the advisor, the estate professional, it is a big deal. Yeah. I just get one story. We had someone who came in, and when we first became clients with us this is probably 10 years ago. Yeah. They gave us their trust. And so we made a copy of it. We had it on our record. We let the insurance company know and the investment company know, and it was all set.
Okay.
And then 5 years later, unbeknownst to us, they completely redid their trust, like a completely new trust.
Okay.
A new UA date, which is the date of inception, new everything. So completely new trust. So it's not like the Heather Branch trust updated. It's the
Heather Branch 2.0. All new. Yeah.
2.0, completely brand new.
Yeah.
We didn't know that. Okay. They never told us. Okay. And then they died shortly after. And it was because they had some major changes in life. Yeah. So they did go to the estate planning attorney and they did spend a couple $1,000s to drop a new trust and a new will. And they didn't tell us. Mm-hmm. So then their beneficiaries come to us saying, here's what it is. And we say, all right, well, here's the problem. The insurance company that has some of your parents' money, they are only going to honor the old trust because that's the beneficiary of your account. Mm. The investment company will only honor the old trust because that's what's on their record. By law, they have to protect your mom's wishes. which according to them and according to the paperwork your mom gave them, this was her wishes.
Got it.
So sometimes we update in a silo rather than update the whole plan.
Yeah.
So for that, there was a legal fight. Now, we were able to advocate. We were able to make it work, but it took almost 2 years of court to get the insurance company to release the money. And everybody's like, this big, bad insurance company. I normally agree. I normally have no problem railing against insurance companies. Do you know how many people fight, lie, and cheat and steal over estate? Like almost everybody. Like when money gets involved, everybody gets stupid and everybody makes bad decisions. Yeah. So as a result, people will flat out lie to everybody to get more of the inheritance. It's gone all the way back to the Bible. Mm-hmm. Like people have fought over inheritances forever. Mm-hmm. So this insurance company says, you know what? I don't owe the beneficiaries anything. I owe Heather, who gave us her money. I owe her fiduciary obligation. Who should get this money? Who did she tell me to give it to? I don't care what the kids and everybody else says, and even this other attorney says.
This is what she said.
Attorneys
to do.
will lie too. Yeah, attorneys are going to lie for their client too. So what did she tell me? Well, she told me I wanted to go to kid A and kid B and kid C gets nothing. Then that's what's going to happen.
Okay.
And you can fight it out and you can deal with all that. And it's all because the client didn't say, hey, I got this new trust. Can you put it on file? It would have been one form we update, one signature, and it's all done. So,
but perhaps she thought that with the working with the lawyer, it was all encompassing. That's the other thing I think that might be a little confusing. How do we make sure that we don't make that mistake? Who's the person that can? We are talking about coordination. Who's the person that can coordinate all of that?
Right, and unfortunately, if it's all spread out with different firms, it's you.
Yeah.
If it's your trust, you're the one. So just know this. Like when it happens, say, all right, great. I have this little checklist. I tell my CPA, my financial guy, and my attorney. We're all on the same page. Great. Then we do that. But that didn't get done. So again, we were able to work really hard to make it happen, but it took a long time. And so it's unnecessary.
Estate planning. It's not just for the uber wealthy, whether you've got 50,000 or 5 million. You want to make sure that the assets do with what you want them to do after you're gone. Also, it's not just a one and done deal. So review it every few years, if not sooner. Make sure your things are up to date. Make sure your people that are working with you know what's going on. If you've got questions about the ABCs of estate planning, Mike and his team, they're here to help you get some answers. Visit us at michigansretirementcoach.com or just click on the links we got posted in the show notes.
Thanks for listening to Michigan's Retirement Coach with Mike Douglas. To learn more, visit michigansretirementcoach.com.
Michael Douglas is an investment advisor representative of Stewards Wealth Planning, LLC, a registered investment advisor. Financial professionals are not licensed in all 50 states. To find out if Michael Douglas is licensed in your state, please call 517-323-7526. Stewards Wealth Planning, LLC is not affiliated with nor endorsed by the Social Security Administration or any other government agency and does not provide legal or tax advice. Annuity guarantees rely solely on the financial strength and claims-paying ability of the issuing insurance company. By contacting us, you may be provided with information about insurance and annuity products offered through Michael B. Douglas, NPN number 9650939.